Good evening, everyone. I'm Parisa Naruzzi with Empower DC. We're really excited to have you here with us tonight. We are going to be listening to the Office of Attorney General's Land Use Division, the Equitable Land Use Division, the attorneys that lead that office, and talking about this is one piece of the puzzle of getting our zoning process to be more equitable, inclusive, representative, and accessible. So today we're talking about a zoning case 22-25. Some of you may remember that last year we actually did some work on this. We learned a little bit about it, got submitted some comments into the record when this case was being what they call set down, which is basically when they schedule it for a hearing. But that hearing is now coming up April 3rd. And there have been some changes to the proposal that Office of Planning had initially submitted to zoning. But again, this is a case that deals with procedures for zoning. So things that have to do with who gets notice, how much time do you have, these types of things that we think are really important to establish an equitable process. So what I'm going to ask is if people don't mind, you could just introduce yourself in the chat. If you're representing a neighborhood, a ward, or an organization, feel free to add that. And what I want to do is go ahead and turn it over to Office of Attorney General and let them, they have a presentation for us and hopefully then have plenty of time for discussion or questions. Our goal is one, to get the information out so that just that people even know that this is happening, right? That this is even being discussed. But two, to support you all with participating in the hearing. And that could be through written testimony, or it could be through being, present for verbal testimony, which is I still think it's all being done virtually. But we'll talk about that more at the end, and certainly want to, make sure that they're over the next couple of weeks, if you decide that you do want to testify, that we, are available to you to provide some support. So with that, I'm going to go ahead and turn it over to OAG. And as they're talking, if you wouldn't mind putting questions in the chat, we certainly will keep, an eye on it. And if it appears that, there's questions that need to be answered midstream, we will stop and do that. Lily's gonna, I think, be really, really good about watching that as well. So let me turn it over to them. Thanks, everybody.
Thanks, Parisa, and hi, everyone. Nice to meet you. My name is Lily Bullitt. I'm from the Equitable Land Use section of the Office of the Attorney General. I'm joined today by my colleagues, Alex Kane and Noelle Wurst. Hey, all. So I'm just going to dive right in. I might not be monitoring the chat as well as I could because I'm going to be reading from my notes, but feel free to, Alex or Parisa, just interrupt me at any point. And I see a giant screen of myself, so I don't know if that's what everyone else can see. Do you want me to share my screen, Parisa, with the, okay, great.
Yeah, go ahead and do.
Okay. Here we go. Okay. Great. Okay, everyone can see that?
No, we can't.
No.
See. There we go. Okay, now we can see it. You can just put it in presentation. Yeah, there you go. Okay, perfect. You're muted, Lily.
Got it. Okay, we're all set. I swear I'm a millennial and I can use technology. Okay, so this is about case 2225, as Parisa said. It's scheduled for a hearing, a full public hearing on April 3rd. I'll send around information on how to participate, and I guess we'll talk about that more at the end as well. And everything here, I just want to point out, is a draft. We are still seeking approval from the front office of the Office of the Attorney General, and we're still formulating some of these ideas and making sure that everything is watertight before we present it to the commission on April 3rd. So this is a procedural text amendment. So it's dealing with the procedures of the Board of Zoning Adjustments and then also the Zoning Commission. We've mostly focused on the Zoning Commission side of things because the amendments should be equal in both, should reflect the same changes on both. So I'm just going to talk about the Zoning Commission changes today, but know that that's also reflected in the BZA. This procedural text amendment has been in the works at OP for a few years now. So OP is the one that is proposing it. And it was set down back in the end of last year, I believe. And these are the 6 focus areas that OIG is particularly concerned about in the text amendment. And so I'm going to run through these today, starting with pre-hearing procedures. So there are various different types of applications. PUDs, map amendments, text amendments, campus plans, design reviews, etc. And each one has a unique process, which can get very confusing for people that aren't familiar with the zoning regulations, even for people that are. I had to spend a lot of time in the regulations to figure out how this all worked. So here is the procedures under the current regulations for campus plans and design reviews. So a notice of intent to file an application, or an NOI, goes out to the affected ANC and property owners within 200 feet. And that is 45 days before an application is actually filed. This NOI doesn't give much information. It's lots of zoning jargon. It talks about, this is a campus plan and design review, but for other cases, it'll talk about FAR and MU10 and all these things that if you are not familiar with zoning or don't have experience, you may not recognize the effect of it and how it may impact you. At this point in the procedure, there's no case record yet. And so someone that receives this NOI doesn't know, has no ability to go and look for more information somewhere online, for example. The only way they can do it is by contacting the developer, which is can be intimidating and takes time. And again, this only goes to property owners within 200 feet of the proposed site and to the infected ANCs. At that point, after the 45 days, the application is filed. At that point, project plans are publicly filed and the record is created. And so at that point, those project plans and, for example, a statement in support of the project are filed. And that is in much more, that describes the project in much more plain language. And so it's a lot easier for someone who doesn't have experience with the zoning regulations or the zoning process to learn what's actually going on here and how they may be impacted by it. And then at least 40 days after that, there is a hearing where, there's a hearing. So campus plans and design reviews don't have set down. I'll talk about set down in a minute, but campus plans and design reviews don't have that. The public only gets notice, the general public, not ANCs or neighbors in 200 feet, only gets notice 40 days prior to that hearing when there's a posted notice on the property. So you would have to actually walk by the property, see that notice, and then go inquire about it online to understand what is actually going on that property. So for PUDs, contested case map amendments, and airspace applications, the process is very similar, except that a set down meeting is required. The set down meeting happens after the NOI, after the application is filed. There's a 35-day period when the application, before the application goes to a set down meeting. The set down meeting is when the commission determines whether the application is ready to be scheduled for a public hearing. It determines that based on whether, based on comp plan consistency, based on whether ANCs or OP or the public thinks that there's more modifications that need to be made to the application before it goes to a hearing. It's basically the first opportunity for the public to provide input into the to the application before the commission. So it's an important process. One issue about ANCs, Alex, I feel like you might be interrupting me at some point. Feel free to interrupt at any point. Okay, so one issue that I also want to mention is that ANCs, when the application is filed, they specifically get notified, and they get what is called an ANC set down form, which is basically a form for them to give their opinion to the zoning commission about whether or not they believe the set down form, the application or petition should be set down. Again, at this point, there's no public notice. even though the case record is created, so there is information online, one would have to know where to look for that information. One would have to know to actually look for that information. So they'd have to either be very closely following the OZ calendar or reading the DC register, which most people don't do, to know that an application has been filed and that it may be affecting them. So a major issue that with the timing of all this is that the general public has not been notified by the time that an application or petition goes to set down. Only the affected ANC and property owners within 200 feet have been notified. And public feedback at the set down meeting is particularly important because it allows the commission to understand if, for example, more information is needed about the impacts of the project, because if there's more information needed, then they might not be inclined to schedule the meeting for a hearing yet. They might say it's not ready. There's still these really big issues that the applicant has to figure out with the ANC, with the community before it's ready to be scheduled for a hearing. Another reason it's really important for public input to be heard at set down is because the further along you get in the process, the more baked an application gets. And so if the public can get involved earlier, and if they have any concerns, they can voice their concerns earlier. That's a good thing for both the public, who has more of a chance to influence the application, and for the developer who, if the public gets involved later and they have these big concerns and they don't have a chance to actually input in it, they're more likely to appeal a process, which leads to a 2 or 3 year Court of Appeals process, which the developer doesn't usually want, and the people in opposition usually don't want. It's better to get these issues all heard and resolved earlier. So OAG has proposed, some amendments. So this is actually the text amendment rulemaking process. It's the same, there's just no NOI for those, which is particularly concerning because rulemakings tend to affect more people. They're more policy oriented. There is a second opportunity for public input after the zoning commission's procedures have ended. But again, it gets rid of early notice. So OAG is proposing one process for all applications. And essentially what we are doing is getting rid of the NOI period. The NOI doesn't give very detailed, sufficient information that's actually of use to the public. So we think that it doesn't go to everyone. So we think that 45 days could be better used on the other end of things. So after the application is actually filed, when there's understandable information in the record, publicly available, at that point, there should be a longer point where more people are notified, the public is notified. So OAG is proposing that that notice be posted on the subject property the entire time after the application is filed. There's the 35-day period before set down is increased to 60 days so that ANCs have more time to review it. ANCs have more time to reach out to their constituents to see their feedback before they give their own opinion. And the public has more time to understand the project and offer their feedback either to the ANC or directly to the commission. A few smaller additions to our overall procedural proposal. One other benefit of this is that it's one procedure for all of the cases. So you don't need to know if it's a rulemaking, a contested case, a map amendment. It's just one procedure for everything, and that simplifies it for those of us who aren't as familiar with the regulations. So all applications and petitions will go to a set down. This will increase the opportunity for public feedback. We seek to replace the NOI period with a longer notice period post-filing. And we also seek to require the applicant or petitioner to meet with an ANC post-filing. So currently the regulations just require that applicants make their best efforts to meet with the ANCs within this 45-day period post-NOI pre-application filing. Best efforts is great. We think that it should be more. And in addition to that, because there's not much information publicly available, meeting with ANCs isn't necessarily the most transparent way for the procedure to play out. And so by requiring the meeting to happen after the application is filed within this 60-day period, when there's more information that's more easily understandable and it's more available to the public, that will increase transparency and public input. We seek to require, as I said earlier, and longer posting at the property so that neighbors who are more likely to walk by can actually understand that something's going on that may affect them. And we also seek to require that notice be sent to tenants, not just property owners living with 200 feet of the property. Property owners indeed will be affected by any proposed development on a new site, but if their property owners are not living there and they're leasing their property to someone else, we think the person living there should also have notice. So as I said, we're asking that applicants and petitioners meet with ANCs. We are asking that notice be sent to tenants, not just property owners. And we finally we seek to require OZ to maintain a system to allow the public to sign up for notifications. So sure, if you walk by the property and you happen to see the sign, you may reach out. But if you know that you're someone that wants to be involved in this zoning process, and even if it's not a property directly near you in your neighborhood, you should be able to go to OZ and say, I want to get notice of this when it goes out. OZ actually does have this on their website already. It just doesn't always work as it's intended to. So we think that by codifying it and put it in the regulations, it'll just make it so that OZ maintains it better and ensures that it really works, because at that point it's a legal requirement. So these are just some benefits of our proposal. It simplifies the process and it makes it uniform, increases notice, it provides more substantial notice. And it allows the ANCs more time to communicate with their constituents and consider the project before they give their opinion on set down or even their full opinion on the project. So that was pre-hearing. I don't know if we have questions yet.
Yeah, why don't we pause?
Sure.
Thank you so much, Lily. So there's a couple of questions I think that you answered. One, Maya was asking, does this process change anything to make it easier for non-owners nearby to learn about the application? And you did address that. You want to repeat that, because I think that's one of the key parts of this.
Yes, so currently the NOIs go out to property owners living within 200 feet of the subject property. OAG is seeking to require that any lessees of those property owners within 200 feet of the property receive notice as well, just to ensure that those living within 200 feet actually living there will actually receive notice.
And a great example of this is, public housing residents are not receiving notice directly to their households when their own property is being redeveloped, right? It's only going to the owner, which is the housing authority, who's probably the applicant and people, people close by. Yeah.
I will say, in a props to OP, they did include in their proposal that tenants of the subject property itself receive notice. And so we're just adding on to that, the 200 feet. Yeah.
Great. Okay. Claire was asking if project changes substantially during this time. Does anything reset? Does any clock reset?
Go ahead, Alex.
I was just saying I can jump in and take that one, let Lily catch her breath for a second. So plans typically, for a PUD case or a design review will typically change a little bit between the time the application is filed and the date of the hearing. I can't recall off the top of my head any time that changes in those cases have required the case to go back to set down. I don't think that's necessarily exclusive. I think if there was something, a really dramatic change, for example, if an applicant had filed a PUD, just a standalone PUD, and decided that they wanted to add a map amendment to it, that would be required to go back to set down, because that would be an additional factor that the commission would need to decide. But typically, the changes that you're typically going to see in these plans don't usually trigger sort of a reset of the clock. I think the place where you do see this more frequently are going to be in things like text amendments, if they are proposed by typically not the Office of Planning, though it may have happened once or twice there. If prior to set down or immediately after set down, there's a significant change to the text that's being proposed, the changes that are being proposed, that might trigger it going back to set down so the commission can reconsider it. So it's on a sort of a case-by-case basis. I want to say, so it can happen. I don't think it happens super frequently, but from time to time it does.
And Sabrina's asking, why is the notice just for 200 feet? Should it be further into the community?
Yeah, I think that's something that we're pushing for a lot of changes here, and we are not sure how receptive OPNOZ will be. So we're limiting that, but that's absolutely something that if you believe it should be more, we encourage you to raise. Absolutely. And we can even talk about it amongst OAG ourselves. This is, again, just a draft.
And so just to be clear, the notice, it comes in the form of a letter in the mail to the people within 200 feet, correct?
The property owners, yes.
Property owners within 200 feet. But everybody else has to be looking at the register, the DC register, or the zoning website, or looking for the placard on the property, right?
Yeah.
Or even maybe their ANC, if they're regularly attending their ANC meetings, their ANCs are involved.
Dean,
you want to go ahead and unmute and ask your question?
yes, I do. Thank you very much. Just to add to that, and I think they did mention it in the presentation somewhere, you can get on on OP's website and be notified of these cases as well. First thing I want to say, just by way of comment, I'm glad this is a draft, because the first title page, you need to change the date from 2022 to 2023.
I haven't caught up yet. Thank you.
Okay. The other thing I wanted to add, suggest that you add to that, is that in addition to notice going to the ANCs, notice also goes to the ward council representative as well. The other thing I had was in the form of a question. One of the things that you've posted, and I don't see it on the slide that was there, but I do know I think the ANC has the authority to waive the set down. If I'm not mistaken, I think you had that on one of the slides.
So they don't have the ability to waive the set down. They have the ability to, there's a 35-day minimum requirement between when the application gets filed and the ANC gets notified, and then when the set down meeting can occur, and they can waive that 35-day period if the ANC and OP agrees to it.
Okay.
But they can't waive the actual set down process.
Okay, no, and that's fine. What you just gave me was better explanation as to what it meant by being waivable. I know this doesn't happen as often as it should, but in a perfect world, when an ANC representative gets notice, they should inform their constituents, in that particular single member district. Being a former commissioner, I can tell you that does not always happen. Now,
Yeah, and the ANC itself only has 30 days to file their set down response if they wish to do that. So they themselves are on a limited time frame, and the public is on a limited time frame, which is one of the reasons we seek to increase that time period.
And I think they will be. I think that'll be acceptable to them, because they have run up against several cases where ANCs may not have even met, or something may have occurred where the meeting doesn't take place until after the hearing. So they don't have the opportunity to be able to comment. And so, and I want to ask this to make sure that I heard you correctly. Is the OAG's office proposing that applicants must meet with the ANC by rule? Is that what you all's proposal is?
Yes, we are seeking to have that requirement put into the regulations. We understand that not all ANCs may be open to meeting with the applicants, and so As part of that proposal, we're going to say that if applicants can show that they made all their efforts to meet with ANCs, provide evidence of that, and actually made these good faith efforts to meet with them, and that the ANC was truly the one who did not want to meet, then
Okay.
that requirement can be waived, but only upon them showing that.
Them
So they have
okay.
to demonstrate that.
All right. Okay. All right. That's fine. Thank you.
Mhm.
All right, wonderful. There was one other question in the chat from Barbara that's asking, what is the notification, et cetera, process for modifications of consequence and modifications of significance? And I actually don't know what those terms mean, so maybe you could.
That's actually in the presentation.
Okay, we'll get to that.
So I'm gonna, it's a
We'll go
great
on to
segue.
Perfect.
Literally right now. Oh, how did you know? Okay, so modifications. What are modifications? Modifications are essentially once a order has been finalized and the applicant or petitioner wants to change something about it, they have to go back to the commission and say, we've already gone through this whole approval process. We don't want to go through it again, but there's an avenue to make small modifications, sometimes more larger modifications to that final order. In the regulations currently, there's modifications of consequence and modifications of significance. I get confused all the time about which one is which. And so one of the great things that OP has done in their proposal is to change the names entirely and say that the smaller ones are now modifications without a hearing, and that the larger, more impactful ones are modifications with a hearing. So that is two awesome things that I think OP has done that makes it just easier to understand what's going on with the process. And through reading the regs, you don't have to search around for the definitions and keep it in your head. So even though they've changed those two names to make it more clear which is which, OP hasn't provided much more definition of what would require a modification with a hearing, what wouldn't. And so one of our proposals here is that they provide some more clarifications as to that. They've done that a little bit. They've said, for example, that map amendments attached to a PUD cannot be altered without a hearing. That has to go back to a public hearing if someone seeks a modification of that. I think things like that, examples of specific requests that would require a hearing or would not require a hearing, are what we need more of in the regulations, just so that the public and applicants know in advance whether or not their application would require a hearing, whether or not their modification would require a hearing. So we are asking that the commission or OP here clarify, just provide some more clarity as to the difference. Another thing that we are proposing is that all modifications, whether or not they require a hearing, go through the first stages of the process that I outlined just before. So I'll just go back to that slide. So that all applications for modifications are filed. It waits the 60 days, and then there's a set down meeting. And at that set down meeting is when the commission decides if it needs a hearing or not. So this solves a few problems. First of all, the notice problem. And so modifications without a hearing. For example, if someone seeks a modification without a hearing, it gets to the commission decides, no, this actually needs a hearing. Applicants then have to start the process all over to ensure that notice has been properly given to the public, which is important. We think that instead of forcing those applicants to go back to the beginning and start the process all over, why not have all applications for modifications provide notice, file their applications, and then the commission can determine whether or not it should go straight to a hearing, or they can just vote on it there if it doesn't need a hearing. That way the public has more notice. The applicant doesn't have to start over if they tried to sneak in this major issue as a non-issue, which makes it better for both the applicants seeking the modifications and the public will have more notice of it. So let me, go back to, yeah, so this is what the process will go through. I hope that answered your question. I'm happy to clarify more though if someone still has it.
Barbara, go ahead. You can unmute.
It didn't exactly answer my question. In our case, the applicants for PUDs often call them modifications of consequence when they're really modifications of significance, and they bury what's changed. In our case, for example, we had two-story retail that was affordable retail. Instead, they want to move a GW, because we're in the GW area, campus store inside and screw the community on the community retail. And they don't consider that major, we do. So we've hired a lawyer, et cetera, I mean, it's ridiculous that they would even do that. So it's unfair, but they've done that. And I want to make sure you know that we really do need these protections in the regs, because the regs just say, you know, it's up to the zoning commission, and they give ridiculous examples of the difference in consequence and significance. So we need proper examples. You can't change, for example, the kind of retail just by changing signage, et cetera. Thank you. I'm sorry.
No, that's great. That's exactly the reason, like the type of thing we're trying to respond to with these proposed amendments, because it happens, we've heard it happen more than once, that an applicant seeks to make these modifications that should require a hearing and the public input, but they put it as a modification without a hearing, and then it just moves forward because the public hasn't been noticed. But I think our proposed amendment would hopefully not allow that to happen as much. So moving on with 2225, OP made some changes to the regulations about map amendments, specifically for map amendments that OP and ANCs submit. So OAG is against it because essentially it allows OP and ANCs to be exempt from important map amendments, to be exempt from important requirements, important notice requirements, community engagement requirements, public participation opportunities, and racial equity analysis. So I'll run through these a little bit. So this is the proposed text amendment from OP. It says, just as it's written, I don't want to speak for OP. I don't know if they intended this or not. I think OAG was just reviewing the language as it's written in the proposed text amendment. And this is how we see the outcome of it and any potential flaws in that outcome or positive results of that outcome. But this proposed text amendment says that except for map amendments requested by an affected ANC or the OP, each application or petition for map amendments must be subject to the requirements of section 304. So if we take a look at what is in 304, which ANC and OP map amendments are exempt from, we see that, for example, there's the NOI requirement in there. So NOIs that go to ANCs and surrounding property owners, OP map amendments would not be required to send notice the NOIs to those parties. It makes sense that if an ANC is submitting a map amendment that they wouldn't have to send notice to themselves, but we still think that surrounding property owners and tenants should know. Also in section 304, there's the requirement to make reasonable efforts to meet with the affected ANC. And so again, if OP is submitting a map amendment, we believe that they should work to engage with the community, and ANCs as part of that community, they shouldn't be exempt from that. There's also the preset down analysis of consistency with a comp plan. So the commission at the set down meeting determines, partially based on how consistent the application is with the comp plan, to allow the application to advance to a hearing. OP does a report analyzing how consistent it is with the comp plan, and that wouldn't be required, for example, for ANC map amendments. We think that the comp plan, there's a lot of effort put into the comp plan. This is something that council passed and is legally binding, it's law in DC, and the consistency with it is important to do that review prior to the set down, especially if that's what determines if the application or petition advances. And finally, there's the racial equity analysis that OP has added in 304.7F. And so you see that some of the language is crossed out. That's because these are what OP is proposing. So everything in bold is what they're proposing. So it's great that OP is putting in these requirements to do racial equity analysis. But I think one of the potentially unintended consequences is that they exempted it from OP and ANC map amendments from section 304. And so they added it in and then exempted it. And I think somewhere in that confusion, it just got lost. And a result of the text as it's written here is that ANC and OP map amendments would not be required to do a racial equity analysis. It doesn't mean that they won't do it. I think OP probably is getting in the habit of just doing racial equity analysis pretty regularly. but that doesn't mean that it shouldn't be a requirement in the regulations. I think having the regulations really reflect what is legally required, which are racial equity analyses, is important. So this is just a brief summary of just what I said. This is for A and C and OP map amendments. I can pause there if there's any questions.
Yeah, let's pause there for a second. Lily, can you just explain, just to make sure everybody's on the same page, what is a map amendment?
Sure, sorry, yes, thank you. So a map amendment is an amendment to the zoning map. And so in DC, there are the zoning regulations, which lay out what you're allowed to do in each zone. And then there's the zoning map, which says which area of DC is zoned as what. And so certain zones have certain requirements. For example, you can only use PDR zones for certain industrial uses, and then there's residential zones. A map amendment might say, okay, this is a residential zone, but we seek to change it to a PDR zone. And so that is a weird example that probably wouldn't happen in real life. Usually they're just seeking to increase how much you can build in a zone. But a map amendment essentially changes what is allowed to be built on the land. And so as a matter of right. And so it does allow those seeking to develop land to do a lot more without seeking approval from the zoning commission, because they can just do it as a matter of right.
Yeah, and I just want to give you two examples of why, this is important. So like in Berry Farm, they've done a map amendment now to that now has basically allowed them to build as a matter of right everything that they say that they're planning to build over the next 20 years. So there's really not going to be zoning hearings for each big part of that development, because they've already gotten the map amendment and gotten essentially the permission to do it. So there's less scrutiny, there's less opportunity for the community to be involved, to negotiate community benefits, all of these types of things as they build back. Another example, Office of Planning had submitted the map amendment for Cromell School to be converted from PDR, from like an industrial use, but it includes schools, to housing use. And so that's a major change, because of course the community has been very consistent for years that they wanted this to be a park and a community center, and the Office of Planning was the one saying, let's propose this for housing. So imagine if that had gone forward without, the community being aware and, set the stage for that, which was completely against what the community wanted. So I see a couple hands. I'm going to go to Caroline and Talabdeen, and then we have some questions in the chat.
Good, thank you. Can you hear me?
Yes.
Yeah. Just a quick question, Lily. If you could refresh our memory on these map amendments, is it only OP and the ANCs that can request map amendments?
Anyone is allowed to propose a map amendment. You can't propose to change the zone of some random property. Usually you have to own the property or be working with the owner of the property, but no, anyone can do it.
Okay, so does the OP proposal make any changes to that, to who can propose a map amendment?
No.
Thank you.
Sure.
Talabdeen?
Thank you, Lily. Thank you, Parisa. And Lily, one of the things I wanted to bring to your attention is a zoning case number 22-07. This was a set down report for a text amendment that was, I believe, recently granted to WMATA at the Western Garage in Friendship Heights.
Mm-hmm.
The reason that I'm on this call is I lead a group of neighbors that are fighting WMATA, and we are now drawing up plans to file a lawsuit against them and the Office of Planning for violating the racial equity component of the zoning amendments, because we are being treated differently at Northern than how WMATA is treating Western. And our question is, in a nutshell, in a non-legal way, if it's not race, then what is it? Because $1 million home in 16th Street Heights is just as valuable as $1 million home in Friendship Heights. And so I would want to use this as a real-time example, like Barry Farms, that is going on right now, where this whole notion of a racial equity analysis just does not exist. It looks good on paper, but when it comes time, to actually have it work, it's not doing that. So thank you for for these proposals that the OAG's office is putting forth.
Sure, yeah, and we're doing a lot of work, as I know Empower is as well, around the racial equity requirement for all zoning actions. And so if you're interested in getting involved more, I'm sure reach out to Parisa, reach out to us, because that's something that OZ has been working on as well. And I know that they would like feedback. They recently released a new tool, but we can talk about that in another meeting. We're happy to discuss that with you.
All right, thank you.
Sure.
And I definitely support challenging in court some things, even because they've been slow walking it, really slow walking it. I mean, it was passed by the council in May of 2021, and they've, almost 2 years later, just released the updated tool for doing it. And now we got to see if it's actually being done. Sharice, you want to go ahead and unmute and ask a couple questions here?
Thank you, Parisa. This is definitely some excellent information, and thank you so much for your presentation. I'm speaking as a former ANC commissioner who have seen some pretty, I'll say, I've seen tricks of the trade to navigate some of what I'm reading here. I'm interpreting do not need to as not obligated to. We've gone to great lengths to keep our communities informed, especially notices of intent, to the degree that in the event that a notice of intent was provided, or if a constituent received notification from the Office of Planning and it preceded our public meeting, then we would schedule a special meeting so that, and we didn't expect the same numbers, of course, but, in order to call a special meeting, we only needed to do this 7 days in advance. And for the most part, we were able to accommodate our constituents and be able to meet as a special meeting to go over and review and to do what we could in the interest of our constituents. One of the things that I'm really sort of, and as you know, before I say that, as you know, the comprehensive plan hearing was probably the longest in DC history. I testified at 11:30 that evening, and my daughter was asleep laid across me as we waited to testify. Interestingly, though, I'm looking at provide the conditions for providing notice of intent. I'm also looking at make all reasonable efforts to attend a meeting of the affected ANC. And so I'd like to somewhat deep dive that, because often we've seen the check the box. Often we've seen tactics where the real essence of meeting this criteria was met only surface-wise. There was really little to no effort on the part of OP. So my question is, in helping the community keep accountability at the forefront, and also ensuring that there's transparency, and it takes everyone involved to maintain that transparency and ensuring that everyone does what they're supposed to do. I'd like for you to talk a little bit more about conditions in a perfect world, what are we talking about here for the notice of intent to the affected ANC? And then make all reasonable efforts to attend a meeting of the affected ANC. Now, with the redistricting, that's another item that I think we need to look at. I personally have been studying these maps. I don't have them all committed to memory, especially for Ward 7, because we've acquired area in Ward 6 that are now Ward 7, and all of the shifts and changes. So what is the OAG's approach to this in expending resources, information, additional due diligence so that constituents really get the coverage that they need, especially in light of the redistricting? Thank you.
Yeah, great question. So first of all, our first attempt is to change this process. So the proposals I outlined earlier about actually getting rid of the NOI, but extending the time frame in which ANCs and the public in general has notice of it, and they can go to the case record online and find in plain language the applicant's intent for the project, expanding the amount of time that exists before the set down hearing, so that we hope that creates the opportunity for the public to get more meaningfully involved, so that they'll actually have notice of it and they'll actually have information that they can understand about it, and then they can actually go to their ANC or go to the commission to get involved. As I said, also about the requirement for applicants or petitioners to meet with ANCs. Currently, it's under the current regulations, applicants or petitioners must make reasonable efforts to attend an ANC meeting. We seek to make that a requirement, and with the slight caveat that some ANCs don't want to meet with applicants. But if that is the case, then it will be that the applicant has to provide evidence to the commission to say, like, look, here are the emails we sent saying that they don't want to meet with us, or like they really have to demonstrate that they made the good faith effort to meet with the ANC, and only at that point can that requirement be waived. But those are our proposals here. We are also thinking about more ways, as you said, to notify the general public. We think that's one of the reasons our division was created, was to say that this process is really difficult to understand, and a lot of people don't even know about it and know how that it affects them or how to get involved. So one of our missions is to help create that zoning literacy and to just notify the public of projects that may be affecting them. And so we are trying to make contacts. We're working with Empower, working with various community groups, notifying them of projects. But if you have ideas about ways that we can meet with community groups who are interested in learning more, or who want to learn about a specific project in their neighborhood, or want more notice, or have ideas about how they can get more notice, we would love to meet and hear about how we can help that happen. Absolutely.
Thank you, Lily. Do you know the requirement of meeting with the ANC? This is not a public meeting requirement, correct? It's just like you need to talk to the commissioners, or is it a public meeting? Like it should be on the agenda.
It's a meeting. It's a ANC meeting. Yeah, not just contact through email. Yeah.
Very good. Okay. So I would hope that it is very clear about that as well. All right. There was one last comment in here I wanted to raise up. Margaret, let's see, there's a few new ones. Margaret was asking, are abutters always defined as those within 200 feet of the site for zoning purposes and for defining who has standing in a dispute?
That's a good question. I'll try to answer it. They're usually in the zoning regulations, 200 feet is the notice requirement, and so that just determines who gets notice. In terms of party status, so if someone lives nearby and is seeking party status because they are uniquely affected by the proposed application, 200 feet is kind of what the commission has in their head, but it's not in the requirements at all. You just have to show that you're uniquely affected or would be uniquely impacted by the development. And then if you're talking about a party in the dispute, in terms of appeal, then there's no requirement. You just have to show that you were impacted by the zoning commission's decision. And so this 200 feet requirement is really only in the regulations, like really only on paper for the notice requirement. but the commission generally sees it as people closer to the property will be more affected by it.
Yeah, and if I can just jump in on that, yeah, the 200-foot requirement is what is in the regulations. To one of the earlier questions we got, it's not an issue that, I mean, we have talked about it internally. I don't know where we will finally come down, but I will just note that like other jurisdictions do have, you know, similar requirements, but obviously with different geographic areas. So there is a range there. So if that is something that people are interested in, that is, you know, certainly something that could be raised. In terms of, as Lily was saying, the impact that the 200 feet has sort of from a legal standpoint, in terms of party status at the zoning commission or the board level, there's a presumption which is held up in case law that if you were within that 200-foot radius, as a general rule, you are probably going to be presumed to be more significantly affected than the general public. Now, that's not always the case, especially in BZA cases, you know, depending on the type of relief, that might not be the case. So, you know, if someone's putting a rear addition on the back of their house and you're within 200 feet, but you're, you know, on the other side of the street in front of their house, it's a little bit harder to argue that you're going to be affected by, you know, their rear addition. So there is flexibility there, but that is sort of the basic legal presumption that if you're within that 200-foot bubble, that you are presumed to be more significantly or uniquely affected than the general public.
One final question here before we move to the next section. Would ANC's decision to not meet with applicants be in the public record? Lily, you're on mute.
Thank you. We were thinking that would be in the record simply because we would want to have the applicant meet with the ANC as a requirement. And so the only way that could get out of requirement is if it was truly the decision of the ANC.
We can go to the next part. And Lily, we're seeing part of your Word document if you want to move it, move it over. Yeah.
Like too many screens up right now.
I get it.
Okay, so next up are OP and OZ text amendments. So text amendments are what this case 2225 is. It's a proposed amendment to the zoning regulations. And this specifically addresses text amendments submitted by OP or OZ. OIG is in opposition to it because again, it exempts OP and OZ text amendments from certain requirements, which I'll run through. So OP, and this is the proposed language of the text amendment in 2225. So it says that this section applies to all text amendments except for OP and OZ text amendments only are subject to 500.6, 500.10, 0.15, and 16. So if we look at what they are and are not required to, this is just a brief overview. I'll run through it a little bit quicker. I'm just going to we're just going to run through, and again, this is as it's written. I have no idea if this is what was intended by the proposal or not, but this is what would be the outcome, how it would be, the outcome of what it would be. So 500.2 requires the applicant to notify OP of any deficiency in the application and then allows them to rectify it. It kind of makes sense if OP is the person submitting it, then they don't have to notify themselves. That one's not too frightening. 500.3 does not subject to OP and OZ text amendments, are not required to place a copy of their application of the text amendment in the public record. They're not required to refer a copy to OP. This is concerning because the public record is how the public gets notice of these petitions and how they learn about what's actually going on. And so again, I'm not sure if this is intended, but as it's written, OP and OZ text amendments would not be required, the OZ would not be required to put those petitions in the public record. It is not subject to 500.4, which requires the commission to determine if it's a contested case or a rulemaking. And so text amendments are all rulemakings for the most part, so this isn't concerning. But they are not subject to 500.5, which requires a set down meeting. It also requires an OP report to recommend whether or not to set down the petition. Set down meetings, as I mentioned, are the first opportunity for the public to provide feedback, for ANC to provide feedback. for OP to voice their opinion on if they think it's consistent with the comp plan or not. So the fact that text amendments from OP or OZ would not be subject to this initial round of community input and feedback is a bit concerning. 500.6, it is subject to. So OP and OZ text amendments are required to comply with 500.6, which requires that OP reports have to be in writing and they have to be filed at least 10 days before the set down meeting, even though the set down meeting isn't required. And so there's some confusing results of this proposed amendment. Not sure what the requirements are exactly. 500.7, it's not required, so the text amendments don't get referred to ANCs. 500.8 requires that ANCs have 30 days to file the set down form, so that doesn't happen with these text amendments. 500.9 is again, the commissions must determine at a public meeting whether to set down the petition. Not required for OP and OZ text amendments. It is, however, required that 3 of the 5 commission members are in concurrence about what to do with the application, whether to set it down or dismiss it without a hearing, which is strange because I then, reading this, have questions about how that happens. If 3 of the 5 commissioners are required to be concurrence to set it down, but a set down meeting doesn't happen, does that mean that it happens not at a public meeting? Does that mean that it just isn't required? I'm just really not sure, and I'm confused. And I have some experience with this, but not a lot. But I think, again, I'm not sure if this is what was intended or if it's just a typo, but this is some confusing results of the proposal. It's not subject to 500.11, so which requires that the commission, if it denies the application, it has to, without a hearing, it has to issue a denial order and publish it. And it's not subject to 500.12. So if the commission dismisses the application, it must recommend, because it needs modifications, it has to recommend what modifications it needs. 500.13 is not subject to. So this would allow the commission to hear the case as a contested case, although this isn't as important because it's a text amendment, which are mostly all rulemakings. It's not subject to 500.14, which again, the petitioner would get notified if the application of the petition gets scheduled for a public hearing. And so this is strange. If OP submits a text amendment and OZ decides to set it down, there's no requirement for them to tell OP, which maybe it just assumes that they would know because they're involved. But again, we just think that the regulations should be clear and easy to read, and it should be easy for the public to understand who is required to do what at what point in the phase through the regulations. It is required, OP and OZ text amendments are required to comply with 500.15, which means that after a hearing date is scheduled, that hearing dates have to be scheduled in a timely manner. And it is required to comply with 500.16, which requires, means there's no parties involved in text amendment, in these rulemakings, text amendment rulemakings. I think this is just a quick recap of what I said. Again, it's just some confusing results of this, so we're against it just because we're not sure what the requirements are for OP and OZ text amendments. And I'll stop there before I move on to the next section because I see some questions.
Yeah, and Lily, I mean, I guess, you know, the text amendments are typically systemic, right? So it's not just for a particular part of town. Is that why they're kind of that's the reasoning behind eliminating a lot of the ANC kind of stuff? Because it would be all ANCs, in other words, that should receive notice.
I cannot speak for OP's reason for why they think it might be okay to eliminate that, but that's what I would think. Yeah.
Or that's so if it's in place now, they're proposing it to eliminate it. So it is in place now, and ANCs throughout the city are receiving notice of text amendments now.
Alex, do you have an idea about whether ANCs are actually receiving notice of text amendments? Because we have heard some feedback where ANCs don't actually get notice, even though it's currently a requirement in the regulations and they're trying to get rid of it. And so either way, it's OIG's opinion that these ANCs should get notice, that they have great weight in these zoning decisions, and they should be notified of the fact that they have the opportunity to get involved.
I would want to double check this, so don't hold me to it, but yeah, I believe that ANCs are, depending on the scope of the text amendment, it is supposed to go to all affected ANCs. So if it is a district-wide text amendment, which most of them would be, yes, it should go to all of them. To the question that just came in the chat, yes, there is notice of the public hearing and notice of the filing of applications and petitions that does go into the DC register. However, it's, again, you have to know that that is a place to go check. And so if you're not checking it on a weekly basis, which unfortunately we do, but normal people who have normal lives don't do that. So there is that sort of form of public notice, but that requires a certain familiarity with the system and how it works to know to check there, to know to go there. And again, it's not always super clear when things get filed. It's not super clear right now when things get put down for set down. So.
All right, Talib Dean, you want to go ahead and then we'll go to the next section?
Yeah, just real quick, and I gotta be real careful here because in addition to being who I am as a community representative, I'm also a small developer with a conscience. But the question that I have for you all, particularly with this last slide that you showed, should you all's office not be successful in some of these recommendations that you're mentioning, is the OAG's office prepared to sue the Office of Planning?
That's a great question.
And look, I'm going to a what do you call it? A meet the OAG tomorrow.
Maybe I'll be there as well. Yeah.
Maybe I'll ask him.
Please do. I'm curious his answer as well. I don't.
Yeah, I will because I will because there have been cases that I have brought to the OAG's office that involved government agencies, and they have not taken either one of them. And there's one that I had to file a federal lawsuit on my own that that I think they should have taken, especially in light of a Supreme Court decision that just came down today on special education. So I will ask tomorrow, but I'm just curious. I mean, from you all's perspective, you all and Alex, you being Lily and Alex, are you all prepared to go to the mat, for some of these recommendations that you're making?
Yeah, I think again, that decision is so far above my head. It's hard for me to speak to it. Okay. I think our focus right now is just trying to get the commission to understand why we think these proposals are good for everyone involved, not just the public, not just applicants and petitioners, but it will help make the process easier to understand and allow the public to more meaningfully and effectively participate in it. So that's our direct focus right now. But again, the other question is miles above my head.
Okay, all right, that's fine.
Yeah.
Great. Why don't we go ahead to the next part?
Sure. So I'm going to talk about the racial equity analysis briefly. This is, as Parisa mentioned, a requirement that was put into the comp plan back in 2021, and it requires the zoning commission to analyze all zoning actions through a racial equity lens. The zoning commission has a racial equity tool, which it just updated in February and released its updated tool. And in 2225, it in each application requirement says that the petitioner and OP must comply with the tool. That's all it says. And so we're making some suggestions that the requirements of the racial equity analysis are further codified. So not just that it says follow the tool on OC's website, but that it actually lays out who does what in the process and what is required at what stage, so that those requirements are absolutely clear. Everyone knows what has to be done, and if those aren't done, then that's reason for a reconsideration, for example. So our specific proposals, So we're asking for these racial equity procedures to be codified, and in that codification, we are seeking 3 procedural changes to the racial equity analysis. So first, we're requesting that the applicant use the data that it receives, and I'll just back up for a second because I realize that not all of you may be familiar with the racial equity tool. The racial equity tool requires OP to provide census data to the applicant to say, here's the snapshot of the community, here's the demographics, here's the income characteristics of the community as it currently exists. It's just a snapshot of the current data or the most recent data. The applicant is supposed to get that information at the time of filing under the current tool. OAG believes that the applicant should get that data prior to filing and then use that data to actually engage with the community to help define who the community actually is. And OAG also believes that that data should not just be a snapshot of the current community, but over time, so that it can provide a more holistic picture of what's going on in the community. So if the data shows a steep decline in lower income Black residents, for example, then that's an indication that those residents may be more at risk of displacement. And the applicant can use that information to say, okay, these are people that are truly at risk. How can we particularly seek them out and engage with them to say that they won't be harmed, to ensure that they won't be harmed by our project? So that data should really inform the community engagement rather than just give a snapshot of what the current community looks like next to a picture of what the proposed development is. We think that they have to be a bit tied together more. And then finally, as part of OP's provision of that data, they have to give an explanation of it. And so it's not just numbers and graphs, but they really say, you know, if there's been a decline in low-income Black residents, why? Is it because of increasing prices? Is it because there was some new development nearby and a bunch of people left? Or really give explanation to it just to help color it and help the applicant understand what's going on so that they can more meaningfully engage. So this is how we envision the process working. Everything in red is just what we're proposing to change. Everything in Black is what actually OP already requires. So we're just asking that the applicant get this data and the narrative from OP prior to filing. They use that report to define and engage with the community. And then as part of their application, they submit a report documenting their community engagement and how their application changed as a result of their community engagement. And then OP, as part of their regular reports to the commission, include a racial equity analysis of consistency with the comp plan. And then finally, the zoning commission evaluates the application based on all of that's been provided to it. I'll pause there. I don't know if there's questions. I can't see the chat. I'm sorry.
No, I don't think we got any new questions on this one. Yeah.
Okay. This is my last section, so we can also take questions after. So rehearings and reconsiderations. I spoke before about the pre-hearing process, which is the beginning of the process, and this is the end of the process. So it's after the commission has made its decision, it's had the hearing, it's made its decision, and it's released a final order. If someone disagrees with that order, or if new information comes out, how do you challenge that that final order? We are asking that rehearings and reconsiderations are more clearly defined. They're both terms that are used in the regulations right now, but it's not, you know, why would someone choose one or the other? Is it, do you get different remedies? Do you have different standards? That's not laid out in the regulations, so we're asking that that be laid out. And overall, we're seeking to make the rehearing and reconsideration process easier so that anyone can get involved, seeking to make the period for filing these longer. And again, this is with the hope that any issue that someone in opposition may have is better resolved earlier in the process before the commission, so that it doesn't go through a 2 or 3 year process where those issues won't get resolved for many years. So this is our proposed differentiation between rehearing or reconsideration. A rehearing is basically if there's some kind of new evidence that has come out that wasn't known before, you can get a new hearing about how that new evidence would affect the application and the application of the commission, the commission's application of the law to the facts. And then a reconsideration wouldn't give you a new hearing. It would just force the zoning commission to consider how it applied the law to the facts if someone believes that it did so incorrectly. So this is the process as it currently exists. So the final order comes out. There's 30 days to appeal it to the DC Court of Appeals. And there's currently 10 days to file a motion for reconsideration or rehearing. These can both end up in zoning approval. One takes much longer. The appeal takes much longer. So this is the proposed amendment in 2225. One thing they're seeking to do is to say that if someone appeals the process, appeals the decision, that any motion for reconsideration or rehearing will be automatically dismissed, whether it was filed before the appeal or after the appeal. OIG believes that that's wrong, that we should actually be making it easier to bring appeals and resolve these issues at the level of the zoning commission. So essentially what they're proposing to do is cut off this possibility. If someone files an appeal, it'll cut off this possibility for reconsiderations and rehearings. So OIG is proposing that actually appeals won't be able to be filed until this longer period for reconsideration has closed. So we're proposing, instead of the 10 days to file a motion for reconsideration or rehearing, increasing that to 30 days. So there'll be 30 days when someone can bring a motion for reconsideration or rehearing. Currently, only parties to the case are allowed to bring a reconsideration or rehearing motion. We're proposing that non-parties also be allowed to do that. One of the main reasons for that is that you don't have to be a party to file an appeal. So if you are a non-party and you have an issue with the final order, your only recourse is to file an appeal before the DCCA, which again takes 2 or 3 years. So we're saying, if you have an issue, let's resolve it quickly at the level of the zoning commission where the case is fresh in people's minds. So we want to open up that process to more people and to make it longer in the hopes of resolving these issues earlier. This is something that the DC Court of Appeals, their rules actually already consider and allow for. They just say that there's 30 days, but that 30 days, if an appeal has been filed, if a motion for reconsideration or rehearing has been filed, then those 30 days won't start until that motion has been decided. So because it's already in the DCCA rules, I'm not sure why we wouldn't take advantage of it here at the zoning commission regulations. So that's it. We have a few more line by line edits to the 2225 proposal, just a few typos or citations, additional smaller suggestions, but these 6 issues here were kind of our big things, our major issues that we wanted to raise today. So yeah, if there's any questions, we're happy to take them now, or any other additional thoughts.
Great. Yeah, thank you so much, Lily. First of all, I know it's a lot of information for you to try to convey in a, easy format. So I really appreciate that. And yeah, let's open it up for comments, questions. And Lily, while we wait to see if anybody raises their hand or puts a question in the chat, we did engage in this case last year at set down. So that when the zoning commission was scheduling, or considering when they would actually hear this case, we put stuff in the record, and I put the link to the record in the chat earlier. I'll put it in again so you guys can see. There's letters from Empower DC, from a number of other folks outlining some of this, and part of that was a strategy that we were trying to play out with OAG, where we put some of the opposition in as soon as possible, so that hopefully even by the time we get to the actual hearing, they've made some adjustments based on that, or at least they come in, the set down, the commissioners are aware of the opposition and they're considering that during set down. So Lily, did the Office of Planning make any changes to their proposal since the original set down based on the filings that we all did?
They did. They had originally proposed that, so for example, the requirement right now is that if you have anything you want to file into the record, it has to be filed by 5 p.m. the day before a hearing. They were going to change that to 3 p.m. the day before, or the day of the hearing. And They wanted to change it to 3 p.m. They got rid of that requirement. They didn't explain why, but that's one requirement they got rid of. Let me just pull up my notes to see the other requirements. So OP had also originally requested that notice of rulemaking map amendments be posted on the property. And that's no longer a requirement. And so again, rulemaking map amendments tend to be larger in scale. And so my guess would be that they got rid of that requirement because they weren't sure how that posting would actually happen, but they've removed that. And they've removed a few other smaller things that didn't seem to be too impactful, but mostly unchanged.
Am I remembering correctly that the energy at the set down was the commissioners were saying that we were wrong about our interpretation of things, and that, you know, I mean, it seemed, am I remembering correctly? Because I have to go back and watch the hearing again, but it felt to me like we were being told, oh, you're blowing this out of proportion, or you're not, you know, you're not understanding this correctly. But in reality, the way that they've written it, exempting major decisions from, for instance, racial equity analysis, it seems to me that they're, you know, they're being they're being duplicitous. You know, they're trying to sort of, yeah, trick people. I don't know.
I think there's a lot in this proposed text amendment, and I think we may be caught up on some details that they hadn't originally seen. And so when we noticed the outcome of those details were concerning, they maybe weren't aware of it. And I don't know how they reacted. It wasn't the most accommodating of our feedback. Yeah. I do think that hopefully in this presentation on April 3rd, we can kind of point out exactly the outcomes, because I'm not sure if they are intended or not, but there are some concerning outcomes.
All right, Vivian.
Yes, thank you. This is very comprehensive and a bit overwhelming. But I do want to first reinforce the need to do anything and everything to increase transparency rather than decrease. And what it sounds like was actually going the opposite direction. The other thing I wanted to know is whether this is the place, whether it is within this effort, that we could also speak to stopping work during the period of reconsideration. So that, you know, certainly, you know, Parisa was talking about, you know, the 2-year period and then the 4-year period, and, you know, the concerns that we have around the Shaw property, that it would be good that nothing happened until after decisions are made in terms of reconsideration or appeal.
Yes, so our proposed, so there's the 10-day current reconsideration period. We are proposing 30 days, and then there's the appeal period, which is 2 to 3 years. The appeal period would depend on, I believe, what the DC Court of Appeal says. If they, if someone would file a motion there before them, and they could stay the final order so that construction wouldn't be able to proceed. I believe it's up to, currently under the current regulations, it's up to the commission whether or not to stay the decision while reconsideration is being considered. But that's something that we hadn't considered, but that we can absolutely, we'll put our heads together at OIG and think about it.
Any other comments or questions? I'm putting in the chat just a basic sign-up sheet. If you think that you would be willing to submit written testimony or do verbal testimony on April 7th, I'm sorry, April 3rd, which is the hearing on this, correct, right, Lily? April 3rd?
Yes, April 3rd at 4 p.m.
4 p.m. Written or verbal again, if you would put your name down just so we can make sure to follow up with you as we, you know, have talking points together, sample letters, that kind of thing. That would be really helpful. Other comments or discussion?
Camera.
Yeah, please.
Going back to the point where the applicant gets a report from OP's planning division prior to filing. and its use of that report. Your third block on that slide was applicant submits with application a report documenting community engagement activity. That's good. We want to see that happen. But are there, how should we say, written expectations on the part of OEG as to what the minimum kinds of community engagement activities should be? I mean, people can just say anything that they feel like, but if they were required as an applicant for a zoning change to describe in detail what they've done and some of the feedback that they've gotten from the community, it would be a much richer step. You can define engagement with the community in in many ways, but there's minimal engagement with the community, which is to just get up and give a talk about what you're applying for in terms of a zoning change, and really engaging the community and getting their feedback and getting their concerns and addressing those concerns.
Absolutely. I think that's a really good point. And something that us at OAG we're thinking through is how to really codify that and require that meaningful community engagement and not just community outreach. The applicant is going and presenting and telling them what's going to happen. We're all ears. We want to hear these suggestions. I think for this case for 22-25, we wanted to not give too much feedback on the racial equity analysis just because OZ did just release their updated tool, and I think they're curious to see how it works before they actually go and change it. So I think we should absolutely be having those discussions about how we can push it further. But I think for now we're a bit limited in what we can suggest that they'll actually have open ears for. But absolutely, we're interested in having those discussions.
And coming out, I hope, with some minimum kinds of engagements and reporting on feedback from the community.
Yes, there are some, I can share the link for the current racial equity tool. There are questions that they have to answer that say, what feedback did you get? How did you incorporate it? How did your application change based on it? And I understand it can go further, but it's an improvement from what there was before, which was nothing in terms of community.
So I just put that section in the chat, what it says in the racial equity tool right now. And this is something that we're really focused on at Empower DC, is trying to figure out how to set some baseline requirements for the community, meaningful community engagement. And that also means baseline requirements for the ANC's part too, right? So like we're gonna have to, and
Yep.
obviously ANCs are volunteers, like we need resources, so this is a great example of where that, focused requirement is needed. There's other DC government functions where it's needed too. And so actually one of the things that we're about to embark on is some research and policy development. And we will, as we have stuff, of course, engage with you all and others in the base, is to see, like, could we create a policy proposal that defines and requires meaningful engagement for many specific types of government action, including certain types of zoning projects, but also things like public land surplusing and disposition, or other significant public housing redevelopment, other significant types of projects. Caroline?
Yeah, I'm jumping back to the 10,000 foot level here. And I guess I've just been sitting here thinking throughout the presentation, which was excellent. Thank you very much, Lily, and very difficult, I know, I might add, the 10,000 foot level. And I'm trying to think, okay, you know, so what is the public policy imperative behind this OP proposal? And I just don't see it. It seems to me OP is basically proposing a solution, if you call it that, to a problem that doesn't exist. That it's almost as if the developers walked into the mayor's office and said, we need to find a way to just streamline, you know, speed these map amendments and other decisions through the zoning commission. But they've never made a case that, you know, that there's anything holding up these decisions, certainly not the public. You know, looking at map amendments, and I've looked a little bit into the history of the commission's approval and disapproval of map amendments, because it came up in a big way in the upflumming debate over the comprehensive plan. And rarely has the zoning commission ever disapproved a map amendment. And if you look at map amendments that have come forward since the enactment of the comprehensive plan, the latest version, I don't see any huge delay, you know, so they can't make a case that they're, you know, something's really obnoxiously holding up progress in this city. They just don't have that case. To me, the only public policy imperative here is, how does the mayor and the Office of Planning and the zoning commission assure meaningful public engagement in these decisions that affect our lives?
Yeah, that's a really great point.
Very.
That's community public engagement is why this process exists. Sorry.
Yeah, no, you're right. And Nancy put in the chat earlier some comments about the fact that, you know, Office of Planning is under the mayor's office, very politically directed, not independent, and they are then informing the zoning commission. So, you know, the comprehensive plan consistency, the development review, that's being done by the Office of Planning. And some would argue that the Office of Planning is too politically driven to do that independently, right? So there's been a lot of talk over the years about how to address that. It would be a major significant change to how the agencies are established. But any final, you know, comments or announcements before we close? We're at 8:01. I put in the chat, we have a forum on Friday at 1 o'clock. I'd love to see some of you there. It's online. We're going to be hearing from some of the experts from around the country who've been part of implementing similar types of racial equity analysis requirements in cities like New York, Boston, and Seattle. So hopefully we'll get some good insight from that. Any other final comments or announcements before we close out? Okay. I just want to thank you all for hanging in there with this stuff. It's tough for all of us. I mean, there's only a few zoning attorneys on the call tonight, and I think even for them, it's a lot because the system is, you know, it's dysfunctional, and we're working really hard to see how we can make it more equitable. Thank you so much. We will send a follow-up email with the presentation, the video, talking points, and I do hope that folks will consider at least submitting something written for the record, if not actually testifying. And also maybe let your ANC know about it. This is an important thing for ANCs to know about it. I'll do my best to send a blast out to the ANCs, but you know, I know ANCs get tons of emails, so they may or may not notice it unless you reach out to them. Thanks a lot, everybody. Have a wonderful evening.
Thank you
Thank you.
for the steps you're
Thank
going
you.
to take.
Thanks. This
Parisa.
was great.
Thank you.